Honorable Chair, Excellencies, distinguished delegates, it's a privilege to be here for the interactive dialogue with you on issues relating to my mandate as the Special Rapporteur on the negative impact of unilateral coercive measures on the enjoyment of human rights. Today, we are all the more observant the growing use of unilateral sanctions by states, despite the multiple reports about the negative humanitarian impact. In addition, sanctioning states are increasingly using different means of enforcement of unilateral sanctions, including by secondary sanctions, civil, criminal, administrative penalties for circumvention of sanctions regimes. Multiplicity and uncertainty of sanctions regimes, higher risks of penalties for their circumvention, reputational risks, uncertain and contradictory interpretation result in growing de-risking policies and overcompliance from the side of states, businesses, individuals, and even UN organs. To my regret, sanctioning states deny the existence of the humanitarian and often disastrous impact of unilateral sanctions and insist on the effectiveness of humanitarian exemptions despite all evidences of the opposite. That's why it's important to establish a methodology providing for the possibility to monitor and assess effect of UCMs, means of their enforcement and overcompliance on human rights. Precise statistics is important to identify the specific impact, to reduce politicization of the issue, and to address human rights violations due to unilateral sanctions and overcompliance via the mechanisms of mitigation, accountability, responsibility, and redress. My country visit to China has demonstrated specifics of legal and humanitarian impact of unilateral sanctions, means of the enforcement and overcompliance even on large and strong countries. Excellencies, distinguished delegates, I have to admit that today the efforts to monitor negative impact of UCMs on the enjoyment of human rights is not systematic. The UN agencies and organs do not include it in the agenda and do not assess the impact of UCMs on indicators they monitor within the scope of their mandates, although the necessary information is often collected at the national level by the country teams, and the role of UCMs as an additional extraterritorial factor is undeniable. The national efforts to monitor and assess negative impact of UCMs are mostly limited to the collection of statistical data by relevant ministries with primary economic rather than humanitarian assessment. Sanctions-related databases are mostly limited in scope, developed with limited participation of the interested stakeholders, often are aimed to ensure compliance with unilateral sanctions of the specific country, put pressure on the specific companies, with access provided on the paid basis. Although all states are under obligation of due diligence and humanitarian precaution to ensure that their activity, as well as activity under their jurisdiction and control, doesn't violate human rights, and despite 3 calls for contributions sent by me for the development of the methodology, establishment of the monitoring tool and collection of information, no evidences has been received that sanctioning states monitor and assess humanitarian impact of their unilateral sanctions. Excellencies, distinguished delegates, development of the monitoring methodology raises a number of serious problems as concern the indicators, sources of information, the need to differentiate between the impact of sanctions and of other actors, to distinguish between impact of different types of sanctions and that of overcompliance, means of calculation and assessment of the results to ensure accuracy. I shall admit that it's not possible to assess impact of separate types of unilateral sanctions, sanctions of a specific country or unilateral sanctions only, but it is possible instead to identify the comprehensive impact of all types of unilateral sanctions, means of the enforcement and overcompliance, which is vital for promotion and protection of human rights. Excellencies, distinguished delegates, for the purpose of consistency of the UN efforts to promote and protect human rights, the methodology developed by OCHA and EASC in 2004 to assess humanitarian impact of the UN Security Council sanctions on Iraq has been used as a starting point during the preparation of the report. Due to the specifics of the case, it's limited in scope, specific for one country, and therefore it doesn't provide for the possibility to assess impact of unilateral sanctions and overcompliance, or take due account of the multiplicity of sanctioning actors. At the same time, its main principles and approaches can and shall be kept for the assessment of impact of UCMs and overcompliance. UN agencies and organs, as well as UN country teams, have not been much responsive to the calls for contribution for the development of the monitoring tool. Although they collect and assess data relevant to many of indicators, presumably as the issue of the humanitarian impact of unilateral sanctions have not been included into the official agenda. At the same time, statistical data collected by the UN entities and on regular basis correspond the majority of humanitarian indicators necessary for the effective assessment of influence on UCM on humanitarian situation and human rights. Excellencies, distinguished delegates, on the basis of information received from states and other stakeholders, as well as during several expert consultations, I have developed a tool for monitoring and assessment of the impact of unilateral sanctions in the format of online application, which can be filled confidentially by any stakeholder to make sure that principles of comprehensiveness, impartiality, and verification are fully observed. The tool will be presented at a side event on 20 September. The current instrument is only the first step for the development of the inclusive, comprehensive, systematic, transparent, and evidence-based system of monitoring and assessment. Due to the politicization of the issue and political discrepancy among states, adequacy of monitoring and assessment can only be achieved at the UN level through collecting information based on specific criteria and indicators from all relevant resources, including UN organs and agencies, states, national human rights institutions, international and national humanitarian actors, research institutions, individual academics, and other stakeholders, based on the principles of comprehensiveness, impartiality, transparency, and verification. Such tools shall collect and reflect information on the annual or biennial basis under the leadership of the UCM mandate with the purpose with active engagement of the Office of High Commission on Human Rights to ensure its sustainability and long-term operation. Excellencies, distinguished delegates, my country visit to People's Republic of China in May 2024 clearly demonstrated that human rights are affected by unilateral sanctions and means of their enforcement, even in countries which have a strong and diverse economy. The visit demonstrated the growing impact of the means of enforcement of unilateral sanctions and consequent overcompliance, as many unilateral measures in this case are not directed against China, but rather constitute secondary sanctions imposed to enforce other sanctions regimes, criminal cases, seizures of goods by the US Customs Authority, and civil suits. Although China was able to mitigate substantially the negative humanitarian impact, nevertheless, primary unilateral sanctions, secondary sanctions, threats with sanctions, and overcompliance affected economic and social rights of those employed in industries and economic sectors targeted by such measures, as well as their right to decent life and freedom from poverty, the right to education, the right to enjoy the benefits of scientific and academic progress and their applications. Many such measures violate the prohibition of discrimination on the grounds of nationality or ethnic origin, as well as access to justice, as well as to effective remedy. They also negatively affect extraterritorially the economies of developing countries following the withdrawal of Chinese business and their investment, or people dependent on humanitarian and development assistance of China. Sanctions against sectors of economy in Xinjiang Uyghur Autonomous Region, coupled with sanctions against large businesses, affect the overall economy of the region, result in disruptions of industrial and trade relations, adversely affect all those involved in supply chains, having a presumed link to this region, and thus resulting in rising unemployment, particularly affecting the most vulnerable. Sanctions against individuals and companies affect freedom of movement, economic rights, as well as the presumption of innocence and the right to due process and fair trial guarantees. Country visit to China revealed the growing misinterpretation of legal instruments or denial of sanctioning states to abide by them. I will take this opportunity to refer to the most alarming tendencies and challenges. First, the presumption of legality of unilateral sanctions, as well as the use of the rebuttable presumption of wrongdoing related to China, its regions, or sectors of industry, are contrary to international law and the principles of responsibility for wrongful acts at the international and national level, and violate the presumption of innocence being the peremptory norm of international law. States shall not shift the burden of proof of legality of their acts to individuals or entities under sanctions. The burden of proof of illegality of acts of omissions of the entities and individuals under sanctions lies within states and only in those cases where state jurisdiction is properly established. Second, non-transparent, costly and lengthy processes to challenge and appeal against sanction-related designations exacerbate fear and over-compliance with sanctions regimes, both inside and outside China. Third, designation of Chinese universities and research institutions, imposition of visa and travel restrictions, suspension of research projects negatively affect the right to education, imposes conditionalities on academic freedom and on the right to benefit from results of scientific research worldwide. Fourth, adoption of enforcement of countering defamation and disinformation legislation coupled with threatening and stigmatizing statements and rhetoric against targeted states, entities and individuals result in arbitrary enforcement and designation, undermine the flow and exchange of information and freedom of expression. Fifth, the scrutiny over the supply chains and rebuttable presumption of their wrongdoing give rise to discrimination against people from the Xinjiang Uyghur Autonomous Region as the very fact of their recruitment is interpreted in the US explanatory documents and practice as an evidence of the use of the forced labor. Excellencies, distinguished delegates, I will focus here on some of my conclusions and recommendations. Preliminary results of the monitoring demonstrate tremendous impact of UCMs on all the humanitarian areas indicated in the questionnaire of the tool and reflect their destructive effect on the most vulnerable groups. In the view of the illegality of unilateral coercive measures and their detrimental humanitarian impacts, sanctioning states shall lift, suspend, or minimize all unilateral measures not in conformity with their international obligations or illegality of which cannot be excluded within the mechanism of countermeasures in accordance with standards of the law of international responsibility. They shall take all necessary measures to ensure that any actors acting under their jurisdiction and control do not affect human rights extraterritorially. They shall guarantee that delivery of humanitarian assistance to the countries under sanctions by humanitarian actors is not viewed as punishable action within their national jurisdiction. In accordance with the obligation of humanitarian precaution, monitor and assess possible humanitarian impact of any unilateral measures before and in the process of such measures being applied. States affected by unilateral sanctions shall take all necessary measures to establish mechanisms for national monitoring and assessment of the negative impact of unilateral sanctions to ensure protection of human rights. I also invite them to submit information to the monitoring and impact assessment tool to strengthen accuracy, reliability, and trustworthiness of the results. UN organs, agencies, and country teams should monitor and take due account on the humanitarian impact of unilateral sanctions means of their enforcement and overcompliance within the scope of their mandates. They should monitor impact of UCMs on the ability of the states under sanctions and third affected states to fulfill their obligations under the conventions concluded within or under the auspice of relevant agencies or organs. They should submit information to monitoring and impact assessment tool annually directly of their country teams. I also call international NGOs to abstain from the practice of glorifying the imposition of UCMs contrary to international human rights obligations in accordance with the principle and norms of international law, as well as relevant resolutions of the Human Rights Council and General Assembly. I also call the Office of the UN High Commissioner for Human Rights to assist me in my efforts to finalize the development of the methodology and online monitoring tool applications for the purposes of monitoring, assessment, reporting, and visualization, to facilitate the establishment of stable cooperation with other UN organs, agencies, and country teams, to receive detailed information on the necessary indicators, to provide support in the development of algorithms for assessment of impact of macroeconomic indicators affected by UCMs on the promotion and protection of human rights, to exercise monitoring, assessment, and reporting of the impact of UCMs within the monitoring tool established together with the mandate. Excellencies, distinguished delegate, there is a number of other points of significance in the report I'm presenting today, but I want to remind that one of the fundamental principles of the modern international law is pacta sunt servanda. That means that all states are under obligation to fulfill their international obligations. They cannot invoke the provisions of its internal law as justification for its failure to perform a treaty. States shall take all necessary legislative, institutional, and administrative measures to eliminate or mitigate instances of over-compliance and to ensure that their activity and activity of businesses under their jurisdiction doesn't violate human rights extraterritorially. I thank you for your attention.